GI WACAF Project, which means the Global Initiative for West, Central and Southern Africa, was established in 2006 as part of a broader joint initiative between IMO, the International Maritime Organization, on the one hand, and IPICA, the Global Oil and Gas Industry Association for Advancing Environmental and Social Performance, on the other hand. And this initiative is called the Global Initiative. The aim of this is to promote cooperation between governments and industry in the spirit of the OPRC 19 Convention, a convention that is key for oil spill preparedness and response, and which will be presented to you today by Colleen. GI WACAF focuses on the Atlantic coast of Africa, as you can see on the map, and covers 22 countries. The main objective is to strengthen the capacity of the 22 partner countries to prepare for and respond to oil spills, and to enable them to better protect their marine and coastal environment. So to this end, we are implementing technical assistance activities, and these activities consist of workshop training. They may be technical or legal trainings, tabletops, or deployment exercises. So in a nutshell here, you can see what GI WACAF is and does and how it works. So you can read this visual representation starting from the top and going clockwise. So this is, as I said, a joint endeavor of IMO and IPICA, so from the public and private sectors, to manage oil spill risks and mitigate associated impacts. It supports 22 African partners countries in the development and implementation of national oil spill preparedness and response systems. And for that, a very important feature is that it maintains a constant liaison with partner countries and the focal points, a network of dedicated focal points in each country to provide tailored capacity building activities. So we organize workshop training, courses, and exercises to encourage better communication and collaboration between governments and industry, but also to encourage partner countries to ratify and implement international conventions. And precisely today, we are going to talk about IMO conventions and the international legal framework of oil spill preparedness and response. Because understanding them and transposing them into national law with a basis for a rapid and effective preparation and response system in place in the event of an oil spill, which also helps the compensation of victims for the damage caused. So today's webinar is part of a series of webinars that address oil spill preparedness and response from a variety of technical, legal, or institutional perspectives. And following an introductory webinar that took place on June the 24th, which, by the way, you can watch the replay of this webinar on our website if you missed it. And this webinar introduced the issues concerning and the challenges concerning marine oil spills and the importance of preparedness and response. And this second webinar today focuses more specifically on the international legal framework governing oil spill preparedness and response. When I say international legal framework, more precisely, the objectives of this webinar are for the participants to understand the functioning of IMO and its role as regulatory body, to gain knowledge on the key conventions relating to marine environment, especially understand the OPRC convention, but also to gain knowledge on the functioning of the IOPC Funds, understand the liability and compensation regime and the difference between tanker spills and non-tanker spills, and finally understand the importance and basic principles of the transposition of these conventions into national law. To do so, we have with us today three experts from IMO and IOPC. Colleen Hoagan from the Marine Environment Division, who will present the functioning of IMO and the OPRC 19 Convention. Mark Homan from IOPC, Claim Manager, who will present the functioning of IOPC, the International Oil Pollution Compensation Funds, and the liability and compensation regime for tanker spills. And finally, Aisha Sharif from the Legal Division of IMO, who will present the principles of the transposition of conventions into national law and the liability and compensation regime for non-tanker spills. So as this presentation was very brief and quick because we are conscious of the time for this webinar, who will last 1 hour and a half, you can find more information about us and our activities in the brochure available to download above the chat box and on our website. And now I give the floor to Colleen Hoagan from IMO for the first presentation on IMO and the OPRC Convention. Thank you very much.
Thank you, Emily. Just 1 second. Okay, thank you. So as Emily mentioned, my name is Colleen O'Hagan. I work at the Marine Environment Division of IMO, and I'm the technical officer responsible for all matters relating to preparedness, response, and cooperation for oil and chemical spills. So before we start, I just want to take a quick opportunity to thank Julianne and Emily for the GI WACAF team for their hard work in organising this webinar and for inviting me to contribute today. As we are focusing today on the international legal framework relating to oil spills, my talk will focus largely on the International Convention on Oil Pollution Preparedness, Response and Cooperation. So the OPRC convention is set out in this booklet. But before I do, I think it would be useful to give a brief overview of IMO, how international legislation gets developed, and why it's important. Just something, and apologies, I can hear some feedback on the call on the webinar, so apologies for that noise. I'm not sure what's causing it. Let me just turn this off. Okay, so just to start, as I mentioned, I think it's important to understand how and why IMO came into being. And this really takes us back to as early as the mid-19th century, where many shipping nations really recognized that the best way to improve safety at sea would be through the development of rules that basically everyone followed, so international regulations as we understand them. So at that time, there were no real means or way to enact this until the United Nations itself was established in 1945. And then shortly after this, 3 years later, in fact, at an international conference in Geneva, a convention was adopted which formally established IMO as it is now the global standard setting authority for safety, security, and environmental performance of international shipping. And really its primary role is to create a regulatory framework for the shipping industry that's fair, effective, universally adopted and implemented by all. And this is exactly what the organization has been doing over the last 70 years. In practice, really the work of IMO is governed by all its 174 member states, and it's supervised by 40 elected member states that comprise the IMO Council. The work gets done through 5 technical bodies or committees, as we call them, which really look at different aspects of shipping. The work of the committees that deal with environmental matters as well as safety and security matters, so the Marine Environment Protection Committee as well as the Maritime Safety Committee. These are also supported by a number of subcommittees which deal with even more specific areas within shipping. So how it works really is that recent developments or shipping related matters or ideas for new regulations get discussed within the relevant committee, and for example, a lot of these come out of lessons learned from significant events such as Torrey Canyon and Amoco Cadiz, as pictured here, were really the catalyst for a number of ideas that led to new regulations and conventions, and we'll hear more about that later. And so if there's really sufficient interest within the committee to support these new ideas and see them forward, then a proposal is typically put to the committee by 1 or more member states to further consider and develop the idea. This may then be assigned to be discussed in more detail at either a specific working group or a specific subcommittee, where the draft regulation is then further developed. And once this is sufficiently developed, then it's sent back up to the main committee for their consideration, and they will really decide whether further work is needed or whether it's ready for final adoption as a resolution or a convention or a code or whatever is appropriate. This schematic on the slide here nicely really highlights the timeline of key events in international shipping legislation, as it really depicts how it's driven by a number of significant incidents, and these are shown here in the bright red blocks, beginning with the Titanic, which really led to the adoption of SOLAS, the International Convention for the Safety of Life at Sea, which now actually falls under IMO's responsibility. Then there was the Torrey Canyon that I pictured earlier off the coast of the UK, which really led to the development of the conventions on liability and compensation, as well as on prevention of pollution, known as MARPOL, etc., and many others after that. Over the years, since it was established, the IMO committees have developed and adopted over 50 legal instruments, and they're listed here. Some of them are listed on this slide and categorized in 3 categories as either preventive legislation, so setting out rules to prevent accidents from occurring or prevent marine pollution from ships. And then there's the mitigating legislation, which really looks at minimizing the impact of any accidents that do in fact occur, and also the liability and compensation legislation, dealing in particular with the damages caused by pollution. And my colleagues Aisha and Mark will really be talking in much more detail about the conventions on liability and compensation a little later on. Just to give some background within the context of the workings of IMO, the liability and compensation conventions fall under the purview of the legal committee, which was actually established following the Torrey Canyon incident to specifically deal with the legal questions that arose from that disaster. This committee actually meets twice a year to discuss and consider any legal issues that may have arisen. And actually it also deals a lot with seafarer matters as well, and the work of our IMO's Legal Affairs Committee also involves this, and at the present time during the current pandemic, they're really kept very busy on this particular issue. But what I plan to talk about for the remainder of my talk is the mitigating legislation, so OPRC in particular, which actually within IMO falls under the purview of the Marine Environment Protection Committee. As we've seen on the earlier slide of the timeline of key events in the early days of IMO, the focus was really predominantly on prevention of shipping accidents, as well as the liability compensation matters. And it wasn't really until the Exxon Valdez incident in 1989 that really the need to focus a bit more on preparedness, response and cooperation was really brought to the forefront. And actually the following year, the OPRC Convention was adopted. And this is the convention at IMO that I'm responsible for, and it has been adopted over 30 years ago now, so it's relatively mature at this stage. But really, like IMO's, like many of the IMO conventions, it needs support and guidance to ensure that it is effectively implemented worldwide. In this, over the last 6 years, I've been working at IMO. I've really had the privilege of seeing how well this convention works and how well it helps its 113 now contracting states to create a global framework for international cooperation in combating major oil pollution incidents. And really its effectiveness is down to its very practical nature, and also, of course, to the commitment of its contracting states to enhance their preparedness to respond to oil spills. The provisions and the obligations of the conventions are set out in the various articles written within them. In the case of OPRC Convention, Articles 1 and 2 really deal with general provisions and definitions, but the Articles 3 to 12 really relate to the more practical matters, which I'll go through now quickly. Article 3, as outlined here, relates to pollution emergency plans and really advocates that ships, offshore facilities, seaports, marine terminals, really anything that with an oil spill risk must establish some spill contingency arrangements or plans that are aligned with the national response system and meet the requirements set out by the competent national authority. This slide here just really shows an example of how this is set out in the United States, for example, where all matters relating to oil spills are governed by the Oil Pollution Act and implemented through an executive order under which various government agencies are given the jurisdiction or the responsibility to address planning for spills from a variety of sources. So, for example, the US Coast Guard are responsible for ensuring adequate contingency planning is in place for vessels and marine transportation, and then the EPA, the Environment Protection Agency, are responsible for onshore facilities and so forth. So clearly set out who has what responsibility under this element of contingency planning. Article 4 of the Convention really looks at reporting requirements. And as we all well know, that rapid reporting and response really leads to the more successful outcome. So the need to ensure timely reporting of any significant discharge or oil spill is really critical. And there's various means of which how to do this as set out in the Convention. And while rapid reporting is critical, as we know, in order to be effective, then what is also needed is an understanding of what rapid action needs to be taken next. Therefore, Article 5 here really addresses what immediate actions need to be undertaken following the receipt of a reported oil spill or of an oil spill report. So this would, of course, include confirming that the details in the report are accurate and then making efforts to further assess the nature and the extent and any possible consequence of the spill, initiating a response by activating, the relevant response system or contingency arrangements, and as well as, very importantly, notifying any neighbouring countries, particularly if the spill is likely to also impact their coastline or their coastal waters. And the POLREP system that we have has really been developed with this purpose in mind, and is shown there on that slide. A key component of the Convention is also the provision to establish a national system for responding promptly and effectively to oil pollution incidents. And this is including clarifying roles and responsibilities of, roles and responsibilities of the various agencies or entities likely to be involved in a response. And this would really help to promote an effective and coordinated response and avoid confusion that often follows in an emergency situation that are already very fraught. And it also avoids the duplication of effort as well, so everyone's clear on what they're supposed to be doing. This also includes the development of the National Oil Spill Contingency Plan. And this document should really set out the overall national policy on dealing with spill incidents, stating, as I said, the agreed roles and responsibilities, the organizational structure of the response, whatever strategies can be deployed. So it's really a key document for every country to have and to maintain. In order to ensure that this national contingency plan can be effectively implemented when it's actually needed, the Convention highlights the need to maintain a minimum level of response equipment in order to address whatever level of risk is present. And it also highlights the need to exercise the plan and ensure that individuals are trained to undertake whatever role they have been assigned during the response. The Convention itself also recognises that most bodies of water are bordered by multiple countries, so they might be in a position to share response resources and pool some expertise. in order to really make preparedness more sustainable in the long term. The images here at the bottom of this slide really depict the location of various resources in both Europe and the Mediterranean, as maintained by EMSA and REMPEC here, in order to facilitate this multilateral cooperation. The need really to further supplement and enhance national and even regional capacity to respond to an incident, understanding that not every country or region can respond to every incident that might occur. This idea of international support is also highlighted in Article 7, and this really advocates for countries to help when they can, or where they can if so requested. But it also highlights the need for the countries that are asking for this help to ensure that they can facilitate any offers of assistance provided. And we've really seen over the years numerous examples of countries as well as industry and other private entities actively answering these requests of assistance. Examples include, for example, the image on the top here showing the Embassy Napoli incident, where the UK and France activated their bilateral Manche plan to respond to this incident that affected both the UK and the French coastlines. The middle picture here on the right, the Rena depicts the Rena incident in New Zealand, where we saw experts in wildlife response from various parts of the world, as well as responders from Australia, answer the calls for assistance from New Zealand. And of course, on the bottom here, we see there's the Macondo incident in the Gulf of Mexico, where the US were literally inundated with very generous offers of assistance. And this actually led to the development of the IMO guidelines on international offers of assistance during an incident emergency response, in order to help this process become much more effective, just due to the magnitude that was experienced during that particular incident. Of course, with all incidents come a unique set of challenges, whether this is due to the specific fate and behavior of a particular oil that is spilled, whether it's due to the organization of the spill management team in a particular country, visualizing the trajectory of the oil, understanding the impact. And every year there's a significant body of research and development dedicated to really increasing and enhancing our effectiveness in preparedness and response, and improving our understanding of how oil behaves in the marine environment. And really, in recognizing the importance of this, the Convention advocates for the holding of symposia in order to share this knowledge gain. And IMO supports these international conferences every year, or they happen on a triennial basis, which really provide a fantastic forum of information exchange and networking for the entire spill response community. Technical cooperation is also key, as highlighted in Article 9 of the Convention, and I spoke about this at length during the last webinar in the series. But I'm lucky enough at IMO to have really worked with many governments and NGOs and industry partners who put a lot of time and effort into delivering trainings, assisting with the development of plans and policies, and providing their expertise and experience for the benefit of others, really to help enhance the level of preparedness globally. And that's really an aim that we all should be striving for. So the importance of this is really highlighted in this Article 9 of the Convention, and there is a lot of work that goes into this. And as I've mentioned previously, the concept of multilateral agreements or international cooperation is really ingrained within the OPRC Convention. Many of these multilateral agreements are outlined within the UN Environment Programme's Regional Seas Programme, and we continue to work, and these regional seas are depicted here in the image here, and we work closely with a number of them to support their work in regional preparedness in various parts of the world. Finally, Article 12 of the Convention really sets out the institutional arrangements, which is really the responsibility of IMO, responsibilities for IMO to perform, and these include the provision of information services during a response, education, training, technical assistance, etc., where we have the resources to do so. And in this context, IMO have developed and published numerous guides and guidelines on all aspects of preparedness and response, as well as the model training courses to really support countries implement an effective national training program. We've supported the International Oil Spill Conference I've discussed, and we provided technical advice and expertise both remotely and on-site during incidents. And certainly, last but not least, we undertake a large number of capacity building activities in this field every year, either in partnership, as I mentioned, with the regional seas agreements or with industry, particularly through the Joint Global Initiative Programme, which GI WACAF falls under, and with our fantastic network of experts worldwide. Recent developments of IMO in this field are the publication of the guide on the implementation of the OPRC Convention and its HNS protocol, as well as the update of the model training courses that I mentioned. So definitely look out for these. And finally, I think I've provided you with the detail on what the convention does. The next and really most important step is to ensure that it's implemented effectively within the national context. In case as a government or owner or operator, if you're faced with a situation depicted on one of these photos here, that you know exactly what to do, and there's an effective system in place to help respond to it. As I mentioned, the guide that we just published gives very clear and practical steps to achieve effective implementation. I've outlined the steps here on this slide, critically beginning with the establishing a sound legislative basis within the national legislation to really enact the various provisions set out in the articles I've just discussed. So that's really a critical sort of sound and basis on which to implement the convention. I won't go through the rest of the steps outlined here now, but I very much recommend using this guide to support your efforts to fully implement this convention going forward. And on that note, I'll end my talk and hand you back to Emily to introduce the next speaker. So thank you very much for your attention and have a good afternoon.
Thank you very much, Colleen, for your presentation on the OPRC Convention. As you understood, this is a very key convention regarding oil spill preparedness and response. And now the next step after having a sound national system for oil spill preparedness and response is to tackle the compensation and liability problem, which Mark will present in his next presentation. So Mark, you have the floor.
Thank you very much. Hopefully you can hear me. Let's see. There we go. Well, good afternoon, everyone. My name is Mark. I'm one of the claims managers here at the IOPC Funds, which is the International Oil Pollution Compensation Fund. My background is as a naval architect and a shipping lawyer, and I've worked at the funds for just over 10 years now. I'm going to talk to you today about this subject, the International Liability and Compensation Regime for Tanker Oil Spills. I've only got 20 minutes to deal with this in detail, so I'm going to start by actually taking you back in time on a history lesson, as it were, as it shows why the international compensation regime was required when it first came into being and why it's still necessary today. So to do that, I'm going to introduce the incident which, as Colleen just mentioned, was really the catalyst for the introduction of an international regime. That incident was the Torrey Canyon incident, which happened over 50 years ago now in 1967, when the tanker, the Torrey Canyon, grounded on a reef off the coast of the United Kingdom, and the entire cargo of 119,000 tons of Kuwaiti crude oil was spilled, causing widespread contamination all along the coast of the UK, France and the Channel Islands. And the problem which then arose for victims of the oil spill was how to get some form of compensation for the damage which had occurred to their businesses and to their livelihoods. And the problem was exacerbated by the facts of the incident itself, because the owner of the vessel was a subsidiary of a US oil company. The vessel was registered in Liberia, and it was chartered to a British oil company, BP. What those facts amount to is a perfect storm for maritime lawyers, because it ties up the courts for years in multi-jurisdictional applications. You could literally hear them rubbing their hands in glee together at the thought of all the money. But those same facts also made it very difficult for the ordinary man who had suffered pollution damage and losses to actually make a successful claim for compensation. Who would he sue? Where would he start his legal claim? Which courts would have jurisdiction? So the call arose amongst the international community to do something to help, and an international regime was developed based on cooperation between ship owners, the oil industry and government to compensate those victims. And that's the regime we're going to be talking about in more detail now. As you can see, very shortly after the incident, the first international convention to deal specifically with this problem, the 1969 Civil Liability Convention, came into being. And that was accompanied by a separate fund convention, the 71 Fund Convention, to provide additional compensation to victims. That 71 Fund Convention is no longer in existence, it's dissolved, but together they formed what we refer to as the previous regime, because they've been superseded by later conventions, namely the 1992 Civil Liability Convention, the 92 Fund Convention, and the 2003 Supplementary Fund Protocol. And those conventions in the current regime provide higher levels of compensation than were available in the previous regime. Now, just to give you some idea of which conventions the states which are attending here today have ratified, here's the list, which you can look at now or later, or you can download a list of all of the member states of the fund from the IOPC Funds website, www.iopcfunds.org. And I thought I'd put this slide here to show you how the number of large tanker spills, that is a spill of over 700 tons of oil, has fallen over the years. As you can see, back in the 1970s, when the conventions first came into force, there was an average of just over 24 large spills per year. But in the last decade, due to a combination of developments in tanker design, better standards of watchkeeping, better traffic separation schemes, etc., the figures are down to just over 2 major spills per year on average. In fact, the statistics show that nowadays 99.99% of crude oil transported by sea arrives at its destination safely. But one statistic that is not shown on this slide, but which I think should be borne in mind, is that since the start of the COVID-19 virus pandemic, 6 times more oil is stored in tankers off coastlines, waiting for the oil price to rise. So there's actually an increased risk of an oil spill occurring if one of those tankers were involved in an incident. And that's always a distinct possibility. The fund's biggest case to date involved a tanker called the Hebe Spirit, which was at anchor, but was hit by a crane barge which had broken its tow line from the tug which was towing it in bad weather. And that led to a spill of some 10,700 tons of oil all along the western coast of South Korea, and 128,000 claimants made claims following that spill. So there's always a potential spill waiting to occur. So what's covered by the regime? Well, the whole purpose of the regime is to pay compensation to victims of oil spills who have suffered pollution damage from a spill of a persistent oil from ships. We're going to discuss each of the highlighted terms in a minute. As you probably know, that many IMO conventions have different definitions of terms, such as ship, depending on the specific convention in question. But here we're talking about spills of persistent oil, that's the heavy oils, such as crude oil, heavy fuel oil, from tankers, vessels which are designed to carry oil in bulk. So it does not apply to container vessels, passenger ships or bulkers, etc. Spills from those vessels are generally bunker spills, and there are separate conventions which for those spills, which Aisha, my colleague, is going to be discussing immediately after this presentation. But this regime, which we're discussing now, applies to pollution damage caused in the territory, the territorial waters, or the exclusive economic zone of the state which has ratified the convention and has suffered the damage. And as a brief aside, I thought I'd also deal with this issue because I know it's arisen fairly recently with a number of spills which have occurred in the GI WACAF region in recent years. No doubt some of the states which are represented here today have a number of offshore craft situated off their coastlines. And the question naturally arises as to whether these offshore craft, such as FSOs, FPSOs, FDPSOs, are covered under the international compensation regime. So to answer that, we need to look at the definition of ship covered under Article 1.1 of the 1992 Civil Liability Convention. And I put there the part of the definition which gives the clearest indication of what the conventions were designed to cover at their inception. It was vessels and seaborne craft constructed or adapted for the carriage of oil in bulk as cargo. But as a result of the rise in numbers of these offshore craft, the IOPC Funds Secretariat was asked to provide a legal analysis to clarify the matter for member states. The fund instructed a leading international barrister with extensive experience of public international law, who concluded that FSOs in general were not ships, because the term is linked to the carriage of oil, which itself involves the navigation of the ship on a seagoing voyage, and FSOs are generally stationary. A working group of interested states was established to consider the findings, and after a lot of discussions back and forth, a hybrid solution was agreed, with a list of vessels which were clearly in or clearly out of the definition, and a grey area where a maritime transport chain test would be applied. We don't have time to go through that in more detail, but you can download a guide from the files section on the right-hand side of the web page here, or you can visit the IOPC Fund website to download it if you want more guidance on that subject. Returning now to the basic principles of this international compensation regime, I mentioned at the start the victim, or the problems that the victims had in the Torrey Canyon incident to identify who to claim compensation from. But under this regime, that is not a problem due to the principle of strict liability. That means in practice, it does not matter who caused the oil spill. The fact that a spill occurred means that the registered owner has liability. However, in return, usually with only a few exceptions, the owner also has the right to limit his liability to a sum of money based on the tonnage of the vessel. There are also time bar provisions which need to be upheld, and importantly, these should be the same under the domestic law of a country as under the conventions, as otherwise there can be problems. And an important element which is necessary for the regime to work is the requirement for the ship owner to be properly insured. And finally, to avoid the problem of where to sue the registered owner, the jurisdiction of the incident will be the courts of the state where the incident occurs. Although I should also point out that one of the key aims of the conventions is to provide compensation to victims without them needing to start legal proceedings at court. So as part of the overview, you also need to know where the money comes from to pay the compensation. The regime is based on a three-tiered system. For those countries that have ratified or acceded to the 1992 Civil Liability Convention, the first tier of compensation is paid for by the ship owner through paying his insurance premiums to the P&I Club, the Protection and Indemnity Club. Secondly, where the country has also ratified the 1992 Fund Convention, the second tier of compensation is paid for when the first tier of compensation is not sufficient to satisfy all of the claims which are made, and that's paid for by the oil receivers in all of the states which have ratified the 1992 Fund Convention. And finally, for those states which have also ratified the Supplementary Fund Protocol, there is extra compensation available, paid for by the oil receivers in those states. So hopefully here you can see the cooperation between the shipping industry and the oil companies, and we'll come on to how the governments cooperate too in a minute. Now looking at the first tier in a bit more detail, as I said, the ship owner has got strict liability, no fault is required. There are very few exceptions, which we'll look at those later. Secondly, the concept or the limitation of liability, which determines how much money the ship owner or his insurer will pay, is based on the gross tonnage of the vessel. It's based on a sliding scale. The bigger the ship, the more money available. That was based initially on the assumption that the bigger the spill, the more expensive it would be. But in reality, that's not always the case. Even a small spill can cost more than a large spill. It depends on a wide range of factors, such as the location of the spill, the type of coastline which is affected, because generally swamps and mudflats are very hard to clean compared to, say, a sandy beach. It depends on the type of oil spilled. Some oils are far more persistent than others. Some will degrade quickly. And of course, the weather and temperature conditions will all play a part in determining how quickly the oil can be cleaned up and how expensive the response is. As I said before, the ship owners are required to have compulsory third-party oil pollution liability insurance and a certificate attesting to that on board the ship. And finally, the convention allows a direct right of action against the insurer of the ship, which is often very important for claimants if it's a one-ship company whose main asset, the ship, has sunk because of the incident, which then may make the ship company itself insolvent. Here is where the government cooperation comes in. I mentioned that there's a requirement for compulsory insurance, and it is essential that governments take their responsibility seriously in this regard. Under the conventions, a ship carrying over 2,000 tons of oil as cargo needs to have insurance in place to cover the third-party liabilities in the event of an oil spill. That requirement is there for the member states' own protection, so member states should take that requirement seriously and should ensure through port state control that vessels that do not have the required insurance are not permitted to trade or to operate in its waters until that insurance is in place. Moving on swiftly, we have here the definition of pollution damage, which is a very wide definition to allow many claimants to make claims. The first point to say here is it doesn't matter where the incident occurs. It could be on the high seas, it could be or it could be within a member state's territory. The question to consider is, where did the damage occur? If the damage was caused by the escape of oil, then in principle the damage is covered under the convention. The second point, part B, is that the compensation regime also covers further loss or damage caused by preventive measures. Here we're talking about, for example, damage caused to a road or a pathway that is used to carry heavy cleanup equipment to get to the beach. Often the transportation of that heavy cleanup equipment causes damage to the surroundings, so in principle, those types of damage are also covered. Looking at the definition contained within the conventions of preventive measures and incidents, the key point to take from this is the concept of reasonableness. That is the key term which pervades the conventions and the assessment of claims. Essentially, what we're trying to do is to compensate those victims who have suffered loss and put them back in the same position they would have been in had the incident not occurred. The definition also caters for those incidents where oil is not actually spilled, but there is a grave and imminent threat of doing so, and expense is incurred in responding to that threat. In principle, those costs of responding to such a grave and imminent threat are also covered. I mentioned before that the ship owner is normally entitled to limit his liability. I've listed there on the left of the slide the reasons why a ship owner may be totally exempt from liability, which are actually very rare, and on the right the reasons why an owner may have unlimited liability. We don't have time to go through those in much detail, but suffice to say it's very rare for an owner not to be able to limit his liability. So we've looked at the first tier of compensation provided for under the 1992 CLC, moving on to the second tier of compensation provided for under the Fund Convention. As you can see, it's designed to pay compensation where the damage exceeds the amount of money available under the 92 CLC, or if the owner is incapable of meeting the obligations, or if the ship owner is exempt from liability under one of the rare exemptions I mentioned in the previous slide. Under the Fund Convention, there's a maximum amount of compensation of 203 million special drawing rights, which is a monetary unit based on a basket of currencies. It changes on a daily basis. You can check the IMF, International Maritime Fund website for that. As I mentioned before, it's financed by oil receivers in 1992 fund and member states, and there are very few exceptions permitted under the conventions for the fund not to be able to pay. Dealing lastly with the supplementary fund, which provides the maximum amount of money available under the regime, a maximum of 750 million special drawing rights, approximately $1 billion. This applies firstly where a state has actually ratified the supplementary fund protocol. Here in the GI WACAF region, I believe that's only Congo, and where the level of damages exceeds the money available under both the 1992 CLC and the 1992 Fund Conventions. There is a minimum requirement of 1 million tons of contributing oil to be received in the state party which wants to become party to this supplementary fund protocol. And if that amount of oil is not received by the actual oil receivers in that country, then the state itself has to make up the shortfall. Just to put the figures I've mentioned there earlier into perspective, here on the graph I put there the amount of compensation available under each of the three tiers. Tier 1, CLC, up to 89.77 million special drawing rights, approximately $123 million. Tier 2, up to 203 million special drawing rights, approximately $279 million. and Tier 3, the supplementary fund, up to 750 million special drawing rights, just over $1 billion. As I mentioned earlier, in common with many other compensation schemes, there are strict time limits which must be complied with. Under both the Civil Liability Conventions and the Fund Convention, rights to compensation will be extinguished unless an action is brought at court within 3 years of the date of the damage. That means in practice that although we try to settle all claims as soon as possible, if the claim is not settled within 3 years, the fund will notify claimants of the approaching time bar and tell them that they need to start legal proceedings at court within 3 years of the date of damage in order to preserve their rights to receive compensation. The second part of the time bar provisions in the conventions say that in no case shall an action be brought after 6 years from the date of the incident. And that 6-year time bar serves two purposes. Firstly, it's an absolute cut-off date, and secondly, it deals with those types of claims where, for instance, oil may be trapped in a shipwreck and there is a potential to cause damage after the 3 years period has expired, but before 6 years has expired. I hope that's clear. Just to conclude this aspect, it's worthwhile stating that we will always apply the same criteria, which is agreed by the member states uniformly across every member state across the world. We have to be consistent. But at the end of the day, the final judgment of the court of the member state where the incident occurred has the final say if a claimant is not happy with the assessment of the fund's experts. I think it's also worth mentioning that the courts very often support the fund's assessments of a claimant's losses because it's based on the concept of reasonableness, and also generally because the standard of proof required at many courts is probably higher than the criteria which the fund require. Turning now to what types of oils the oil receivers have to report when asked to contribute, here's an extract from our oil reporting form, which you can find on our website. As you can see on the left-hand side, it mentions that contributing oils are generally persistent oils. And on the right-hand side, the non-contributing oils, which may be transported by sea, but do not have to be reported, and members or the oil companies do not have to pay a contribution in respect of those non-contributing oils. So now that we know what oils need to be reported, we also need to know how we capture that information from each member state. And here is where the oil reports come in. Under the conventions, there is a requirement for any entity that receives more than 150,000 tonnes of contributing oil per year to report the receipt of that oil in order to pay contributions. And here is where the cooperation with the government comes in, because all the oil report, although the oil report is filled in by the oil receiver, it has to be checked by the competent government authority and then sent back to the funds by the competent government authority. So we've looked at the international regime, what are the responsibilities and who pays for it. We want to quickly look at what types of claims are covered under conventions and what information is required, what criteria are applied in order to receive compensation. Here we have the 5 main categories of claims which we will receive. They're fairly self-evident, so I'm not going to spend time on those, but they cover the types of people who are affected both physically and economically. Just to give you some more information about presenting claims, these are the criteria which are agreed by member states and which are applied to every claim around the world consistently. Firstly, the burden of proof is upon the claimant to prove the loss or the damage, and there is a clear link of causation between the pollution and the loss complained of. We can also only pay for losses which are economically quantifiable. We cannot pay for so-called moral damages. And most importantly, we can only pay for what is reasonable and justifiable based on the information that is available at the time of the incident. Finally, the loss or expense has to be incurred. We cannot pay for future losses that might happen at some stage in the future. Moving on quickly to look at the process of submitting a claim, we can pay compensation for the reasonable losses suffered by anyone that has suffered pollution damage. It could be private individuals, government authorities or agencies, companies, whoever's been affected. The claim has to be submitted in writing, containing the details of the claim and the claimant, with sufficient detail to allow us to assess the claim on the basis of the information submitted. And it's submitted to one of the 3 parties there, either the local claims handling office, if we establish one in the country which is affected, or the ship owner's insurer, P&I Club or his local representative, or the 1992 fund itself. And once the information has been collected, we will then make an assessment with the P&I Club involved, and we will then make an offer of settlement to the in writing to the claimant, and they can either decide whether to accept the offer, or they may wish to provide further information, or they may wish, as a last resort, to actually commence legal proceedings. Just to give you an overview of how much money has been paid over the years, it's close to £750 million, which has been paid in compensation or indemnification. So it's a big money here. And one of the other things we are involved with, or one of the important roles which the funds fulfill, is to engage with member states and to help them through a variety of means, such as workshops, meetings, visits, etc., to ensure that member states are as well prepared as they can be before a spill occurs. So it's essential that there's good cooperation between the member state and the fund to ensure that the regime works as it's intended to, with victims receiving compensation promptly. One of the other tasks that we undertake is to assist member states with transposing the conventions into domestic law. That's a process which is ongoing with some of the member states represented here today, and which Aisha will talk about in more detail in a second. Just want to refer you to our website, available in 3 languages, where you can download meeting documents, background information, and statistics on the actual incidents we're involved with, either presently or have been involved in the past. And also, here are a few of the publications which you can download from the website, or you can request in hard copy with specific guidelines for various sectors of the claims, the text of the conventions in 3 languages, financial information about the expenses and compensation paid over the years. So that summarizes the presentation. Be available at the end for any questions if you have any. I'll pass you over or back to Emily now. Thank you.
Thank you very much, Mark, for your presentation. Very comprehensive in such a short time. Now I will hand over to Aisha Sherif from IMO, who will present the compensation and liability regime for non-tanker spills, and present also the principle of transposition of this convention into national law. Aisha, you have the floor.
Thank you very much, Emily. Good afternoon to all, and thank you very much for the opportunity to present during this webinar. My presentation.
Your voice is very low. Can you speak closer to the microphone, maybe?
Yeah.
Thank you.
Is it going okay now? My presentation is going to be on the liability and compensation for non-tanker spills, specifically on the Bunkers Convention, and some general principles of implementation into the national law. So, can you hear me now?
I hear you very good, thank you.
Thank you. So, the Convention on liability for damage due to bunkers was adopted in 2001, but it took 7 years for it to enter into force. It entered into force internationally in 2008. And it's quite widely ratified. As you can see, as of today, there are 98 contracting states to the convention, representing 95.05% of the world tonnage. It's a convention that was quite easy to adopt in the way that it follows the Convention on Civil Liability for Oil Pollution in most respects, but with differences. And it was very important because it really plugged a gap by addressing for the first time the problem of pollution caused by the escape of bunkers from general cargo ships. So this is the main difference with the Convention on Civil Liability for Oil Pollution. An important fact to remember about conventions, please, and especially if you are considering acceding to conventions, always read the objective of the convention, which is usually in the preamble of the convention. It will show you why this convention was adopted by states and how it can benefit your country when you accede to it. So the objective is to ensure that adequate, prompt, and effective compensation is available to persons who suffer damage caused by spills of oil when carried as fuel in ships' bunkers. So the Bunker Convention is similar to the Civil Liability Convention, and it follows the same important principles: strict liability of ship owners, limitation of liability, compulsory insurance, certificates of insurance, and direct action against the insurer. I will go through these principles in the presentation. Because I am a lawyer, and I really wish that as many lawyers and legal drafters are following this webinar, it is important to go through some definitions and to remember that the definitions in an international treaty are the result of years of negotiation. Please read them, understand them, and do not modify them in your national legislation. This is where problems occur. I will go through some essential definitions of this convention. A ship, first of all, and as you saw from Mark's presentation, a ship is not always defined in IMO conventions, and it can mean many things. But ship is defined in the Bunkers Convention, and it's quite a broad definition: any seagoing vessel and seaborne craft of any type whatsoever. So it's a broad definition covering a large number of floating objects as well as traditional ships. But the important thing to remember is that this convention will not apply unless the vessel is carrying bunker oil. The ship owner's definition is also important because it includes a variety of persons, not only the owner, but also the registered owner, the bareboat charterer, the manager, and the operator of the ship. And whenever ship owner is referred to in the convention, it refers to all these persons. Another important definition is bunker oil. It's a broad definition that includes hydrocarbon mineral oil, lubricating oil used for the operation or propulsion of the ship, and any residues of such oil. So why did they use a broad definition? To be able to include as many ships as possible in this convention, but it is necessary to prove the intention of the use of the bunker oil, to make a distinction between the fuel and the cargo oil. So we are not talking about tankers here, but about ships that carry oil as bunkers. Another definition which is important, and it follows the definition of the Civil Liability Convention, is the definition of pollution damage. It's in Article 19. The scope of application of the convention, it's in Article 2. The convention applies to pollution damage caused in the territory, including the territorial sea of a state party and the EEZ of that state party. And it also applies to preventive measures wherever taken to prevent or minimize such damage. And it is an important point also of this convention. And there is also a definition of preventive measures that follows the definition in the CLC convention. The liability of the ship owner, as we said, these conventions, CLC, bunkers, HNS, Nairobi, there are conventions on liability and compensation. So they are there to help the victims of pollution. So to make their job easier, these conventions use the principle of strict liability of the ship owner, meaning that the claimant does not have to, there is no requirement for the fault, for the liability to arise. So the ship owner at the moment of the incident is liable. But the consensus was reached that because there was this strict liability of the ship owners were able to limit their liability. So this principle of strict liability is very important, and there are few exceptions and exclusions to this liability. I will not go through them. You have them on the slide, and they are very similar to the exclusions in the CLC Convention. So to make the difference between the CLC Convention and the Bunkers Convention, of course, one exclusion is that this convention, the Bunkers Convention, is not going to be concerned by the pollution damage covered by the CLC, of course. So, as a pendant to the strict liability of the ship owner, the ship owner can limit his or her liability, and this is where the difference with the CLC Convention arises. The Bunkers Convention does not provide for the amount for the limitation of the liability in the convention itself. It refers to the right to limit liability under the applicable national or international regime. So this right to limit liability has to either be inscribed in the national legislation as such, or the state can adhere to the limitation of liability under an applicable international convention. And in that case, it would be the 1976 limitation of liability for maritime claims convention. So to go back to this convention very briefly, it was a convention that was adopted in 1976, and it provided for some limits of liability of the ship owner. And because these limits were quite low, the convention was amended in 1996, but it was amended through a protocol that raised the limits of liability. And in the protocol, the possibility of amending the limits of liability was the possibility to limit these limits, to amend these limits, through tacit acceptance was introduced. So in 2012, the limits of liability were amended and increased through an amendment to the 1996 protocol. So if the state decides to apply the international regime on limits of liability through the LLMC, then the owner, charterer, manager, and operator are entitled to limit their liability pursuant to the terms of that convention. And in that convention, Article 6 sets out the limits of liability calculated based on the tonnage of the relevant ship. So here I have put the limits according to the tonnage. The limits of liability for personal claims, as you can see, if the vessel is of a maximum tonnage of 2,000, the limits provided for in the 1996 LLMC protocol as amended are of 3,020,000 accounts of SDR. Again, we are talking about special drawing rights. These are for personal claims, and for other claims, these are the figures. But of course, it depends on the tonnage of the ship. So, which ships must be insured for the Bunkers Convention? Ships greater than 1,000 gross tonnage. So it is another big principle of the Bunkers Convention. After the strict liability of the ship owner, the limitation of liability of the ship owner, the ships have to be insured, and they have to carry a certificate of insurance on board the ship. but only ships greater than 1,000 gross tonnage have to be insured. This was the result, again, of negotiations during the adoption of the convention. Some countries wanted a lower tonnage, other countries wanted a higher tonnage, and this was the consensus that was adopted. Who has to be insured? Who must be insured? The registered owner. So the evidence of the insurance is through a certificate attesting that insurance is in force, and a certificate shall be issued to each ship by the appropriate authority of a state party. This certificate is issued by the appropriate authority of a state party after a blue card is issued by the insurer. So first the insurer has to issue a blue card to the ship proving that there is in place insurance meeting the liability requirements of the Bunkers Convention. And based on this blue card, the state party can issue the certificate. For states which are not parties to the convention, the certificate can be issued by the appropriate authority of a state that is a party to the convention. So this convention is very important, and it is difficult, if not impossible, for ships to navigate without the bunkers certificate on board the ship. But if the any state party can issue the certificate. So the certificate has to be carried on board at all times. And it's the state that shall determine the conditions and issue and validity of the certificate. The last important principle of this convention is the direct action against the insurer. So it is, again, a convention that is there to help victims of pollution damage. If they cannot claim compensation against the owner, can you hear me? Okay, so
but now we can hear you again.
Thank you. So the claim can be the claim for compensation can be brought directly against the insurer, and then, of course, the insurer may be able to limit the liability as would the ship owner. So, if there is no insurance in place, the state party shall not permit the ship under its flag to operate at any time. So it is an obligation on the state party, and I'm emphasizing that because this obligation needs to be reproduced in the national legislation implementing this convention. I'm not going to spend time on this. Of course, there are time limits. There are time limits to bring an action against a ship owner, and these are exactly the same provisions as in the CLC convention. There have been some problems faced by some administrations when issuing certificates, when they had to assess the solvency of some of the insurers or guarantors. And the IMO adopted guidelines for accepting insurance companies, financial security providers, and the international group of P&I associations. These guidelines have been issued in the form of a circular letter that you can find on IMO docs. So when it comes to implementation of conventions in the national legislation, there is one big principle of international law that is important to remember, is that when a state is a party to a convention, it has to implement the convention in the national law. And this principle is based on Article 26 of the Vienna Convention on the Law of Treaties, Pacta Sunt Servanda. So every treaty in force is binding upon the parties to it and must be performed by them in good faith. It is not just a question of acceding to a treaty, it needs to be implemented and in good faith. So to implement a treaty, it's not only a question of acceding to the treaty, it needs to be effectively implemented. And for this, there is no secret. A treaty has to be understood. The state has to understand the obligations upon it and has to know how to implement these obligations. So I took the example of the Bunkers Convention. Any state that ratifies the Bunkers Convention becomes party to it 3 months after the date of deposit of the instrument of accession to the Bunkers Convention. So there is time before the accession and even after the deposit of the instrument of accession to prepare for the implementation of this convention. And another principle to remember as well is that when you accede to a treaty that has been amended, the accession is to the treaty as amended. So how to transform an international treaty into your national system? Well, first of all, states have to have a very clear idea of their own national legal and legislative system. Is an international convention becoming automatically part of the national law? Or is there a need for transposition or incorporation of the international treaty into the national law? How is this done? At what level of the legislation will you need to incorporate the legislation? At the primary level, at the primary legislation, such as an act or a law, or in a subsidiary part of a legislation? It really depends on the countries and on the systems. Is there an obligation to publish the international treaty? Is there an obligation to publish the amendments to an international treaty? The Bunkers Convention, for example, has not been amended, but as I showed you, the LLMC Convention has been amended. What happens to these amendments? Do you need to publish them in your country for these amendments to become law? You have to think about these issues before, ideally, before you accede to a convention. When it comes to implementation of the Bunkers Convention, do you already have in place legislation, for example, implementing the Civil Liability Convention? As we saw, a lot of principles of the Bunkers Convention are similar to the Civil Liability Convention. So these principles might already be in your national legislation, and you may it may facilitate this for you, because then you can amend your existing legislation, for example, to incorporate the Bunkers Convention. Or maybe you do not have a legislation in place, then you need to draft new legislation. If you have legislation on the protection of the marine environment, you have to ask yourselves, is this the correct piece of legislation that I need to amend to incorporate the Civil Liability Convention or the Bunkers Convention? Or should I have a piece of legislation dedicated to liability of ship owners and marine operators and compensation of damages caused by oil or bunkers pollution? We suggest having a timetable before the country accedes to a convention, knowing how long you will have before the convention enters into force for your country, and working towards these deadlines. A very good tool as well is to have a comparative table with the obligations in the convention and how you would transpose these obligations at your national level. And to finish my presentation, I would like to remind you that definitions in the legal conventions on liability and compensation are very important. Please follow them and try not to amend them in your legislation unless there is something that needs to be adapted to the national level. But these definitions are the result of long years or weeks of negotiation, and they are understood internationally. Please do not modify them if you don't need to. And always think in terms of obligations to ensure that the ship owner is responsible, that the ship owner may limit their responsibility, in obligation to have insurance on board ships of your flag, but also obligation to check insurance certificates for ships calling at your ports. These are obligations, and these need to be reflected in the legislation. After that, it is your choice to reflect that either in the primary legislation or the secondary legislation. But these are obligations that need to be reflected. Because there are matters concerning issuance of certificates, your legislation has to reflect how these certificates will be issued, by whom, and the legislation also has to provide for offenses if the certificate is not issued or if the certificate has expired and has not been renewed, etc. And another matter that is important to have in the national legislation when it comes to liability conventions is to ensure that courts have jurisdiction to hear claims for compensation, because as you saw, for example, in the Bunkers Convention, there is no other fund that is going to compensate. So everything will have to be heard by national courts in terms of compensation. So national courts have to have jurisdiction to hear claims for compensation when it comes to bunkers pollution, and as well have to recognize judgments from courts in other states' parties. So these are matters that need to be reflected in the national legislation. That's it. Thank you very much for your attention.
Thank you very much, Aisha, for this presentation. And despite the small connecting problem, I think we could follow you very well. So thank you very much for that. Now we will have a Q&A session. Before the Q&A session, maybe a small poll to see if you have followed well this webinar. The results will be anonymous, don't worry. So I will display a poll that you can answer, and then we will see how many people got right, and Mark will be able to answer that question. And then we will take the question that you asked in the chat, and that Julien, working in the control room for the technical problems, thanks Julien, has flagged to me, and then I will ask the presenters. So can you see, are you able to see the poll in the chat? I see some are already answered. I'll give you some. We have different answers. Yeah, maybe we can end the poll now. I think everybody has answered. No, not yet. It changes. Okay, I will end. I will end the poll now. And Mark, can you provide the answer? We have very split results.
Yes, it was interesting to see the results of the spill of the poll there, which went from 50-50 down, up and down a little bit, and almost ended up back at 50-50 again. Crude oil spills from a pipeline in the territorial sea. Do the CLC and the Fund Conventions apply? The answer is no, they do not. The CLC and the Fund Conventions govern the carriage of oil by sea from tankers, vessels which are designed to carry oil in bulk as cargo. If it is a pipeline spill, it is not covered by an international convention that we have discussed today. You probably have to look at domestic legislation to see what is covered under the local legislation. So no is the answer on that one.
Thank you very much, Mark. Now we will take the questions asked in the Q&A box. First question, participant, our focal point in Gambia. What is the main difference between the CLC and LLMC? So maybe Aisha and Mark, you can provide an answer to that question. Aisha?
Yeah, sorry. So maybe Mark should start.
Okay, sorry.
Yeah, and then I.
Okay, well, I say. Okay, yes. So the Civil Liability Convention is very specific, governing oil pollution from vessels designed to carry oil in bulk as cargo. Aisha will go on to explain more, but the LLMC is a wider ranging convention, predated the CLC originally in its earliest form, but there are a different variety of claims covered under the LLMC to the CLC. Aisha?
Yes. So yeah, exactly. The LLMC is it's not related to oil pollution or specifically. It's there to it's a uniform rules relating to the limitation of liability for maritime claims, and there are a variety of maritime claims covered by LLMC. Claims in respect of loss of life or personal injury or loss of or damage to property, claims in respect of loss resulting from delay in the carriage by sea of cargo, passengers, their luggage. There are a variety of claims covered by the LLMC. So the LLMC was the instrument that the drafters of the Bunkers Convention and the Nairobi Convention thought about when it came to compensation for claims under these two conventions. But it's not specifically for oil pollution or bunkers pollution damage.
Thank you very much, Mark and Aisha, for your answer. I have many questions, so I hope we'll have the time to take as many as we can. Another question is, are the governments being audited for the implementation of contingency arrangements, and where or are the observation findings of such audits being published publicly? Maybe Aisha, you can answer.
So the IMO member state audit scheme does not include the OPRC or the liability and compensation conventions. These are not included in the scheme at the moment. They may in the future, but if we are referring to the IMO member state audit scheme, they are not included in this scheme at the moment.
Yeah, Colleen?
If I may add to this, Aisha obviously is correct in that they're not part of the audit scheme. Basically, member states and contracting parties to the OPRC Convention are advised to, in effect, audit their own contingency arrangements in country through using exercises There's also various other tools out there, questionnaires, etc., to understand that all aspects of contingency planning have been taken into account. But exercises are really a good opportunity to look at the weaknesses in the planning and then make amends for them, and improve the plans going forward. So it's very much encouraged to do some form of auditing of any contingency arrangements in place.
Thank you, Colleen and Aisha. Another question, what is the position in case of oil spills within a port from wreck residual bunkers? Does any of you have the answer to that question? Aisha or Colleen, maybe?
I think I am assuming that the intention is on liability. The question is on the liability and compensation related to such.
Yeah, I guess maybe.
If it was related to response, then obviously this would be something that should be addressed within the risk assessments that led then to the development of the contingency planning, and hopefully addressed in that format. If it's on the liability and compensation issues, I'll leave that to Aisha.
Sorry, can you repeat the question, please?
Yes, sure. The question is, what is the position in case of oil spills within a port from wreck residual bunkers?
That's a good question. So, if we look at the definition of pollution damage, it's loss or damage caused outside the ship by contamination resulting from the escape or discharge of bunker oil from the ship, wherever such escape or discharge may occur, provided the compensation.
There is also an element here as well, because there may be some of the bunkers from may be covered under the CLC and Fund Convention. If it's a tanker, it doesn't matter where that wreck is. If it's the wreck is located in the port and the bunkers come from that wreck, we have had, if the ship is just sunk and there's a spill, it's now a wreck, but the bunkers have come from a tanker, so therefore that is pollution damage. So there is a potential for compensation available there. There's also an element here about the wreck removal convention as well, which may become touched on the side of this as well.
Yeah, exactly. And that would be a matter to see which convention applies, if it's the wreck removal convention or the bunkers convention. And this, I guess, this would be left to the interpretation of a court.
Okay, thank you very much for your answers, Mark and Aisha. Very tricky one. The participants are very questions. I have a question here on, I would like to know if IMO have sponsored similar workshops with the aim to help those countries prevent oil spill and talk about the importance of the prevention of pollution convention in the African countries. So maybe I can answer that, because yes, under the auspices of the global initiative and especially the GI WACAF, the project that is organizing this webinar, we have provided workshops in 22 African countries, so from of the Atlantic coast of Africa, from Mauritania to South Africa. And that's basically what GI WACAF is doing. We have funds from both from the IMO and from the oil industry, and we provide technical activities such as workshops, trainings, exercises, tabletop or deployments within these countries, working in close relation with the governments of these 22 countries to tailor our activities to their needs. You can find more information in the brochure displayed in the files to download or on our website. Another question, can you please clarify how an offshore drilling unit is classed, specifically considering a well blowout scenario, not a fuel or drilling fluid spill? Who wants to take this question? I guess it relates to which convention applies.
Yeah, and I suppose also the definition of ship aspect as well to this. There are certainly under the CLC and fund conventions, as per that guidance document, which I mentioned in the presentation, in general, anything which is involved in offshore drilling is not covered under the CLC or fund convention. They're not involved in the carriage of oil, they're stationary units, and therefore you would have to look at domestic legislation generally, or an interregional agreement as opposed to a global convention. Many of the offshore activities are dealt with by regional agreements between neighbouring countries, but they're not covered by the international conventions.
And if I may just put some clarification in there in relation to the OPRC convention, offshore facilities would fall under the provisions of that convention. As I mentioned, basically any sort of entity that poses a risk of an oil spill in the marine environment would fall under the purview of OPRC. So there is a requirement there for having contingency arrangements in place.
There's no compensation available under that, that's the thing, yeah.
No. Thank you very much for your answer, Colin and Mark. And maybe a last question to take, and then we will end this webinar. There are two related questions regarding the changing nature of bunker fuel being used on vessels, especially when future fuels, I guess lower sulfur fuel, may not fit under the definition of bunker, or will they fit under or not anymore? I think that's the question. Maybe Colin or Aisha, you want to answer that question if you have any clue?
It's the question related to
the nature of the changing nature of the low sulfur fuel. If it will still qualify as bunker, I guess.
Yes. I've had this question also in the implementation of MARPOL Annex 6. Look, that would also be a question of interpretation, and the Secretariat cannot give this kind of interpretation. That's up to state parties. But the definition of bunkers of bunker oil in the Bunkers Convention is quite wide, and this is what serves as for the propulsion of the vessel. So I guess it would be included, but again, we always say that the Secretariat cannot provide interpretation of treaties, only state parties can. But I guess, of course, it would be included in the definition of bunker oil.
Thank you.
If it's what is important is the intention of the use of this oil, and it is to propulse the vessel.
Okay.
But I don't know, maybe Colin has another idea.
No, my understanding, Aisha, is it's a very broad definition of bunker fuel, which is anything that propels the vessel, in which case these newly developed fuels are being developed for that very reason. Therefore, you would imagine should fall under that definition.
Yeah.
Thank you very much. And maybe in the minute that is left, we can answer a last question. Is there a way to submit a successful claim where the identity of the ship cannot be determined?
Yes. We have a number of mystery spills, which we've dealt with in the past history. But as you know, with oil, you can fingerprint the oil. And generally, that is the first thing we would try to do, to try to identify which oil came from a vessel in that vicinity, because it's generally easy to see where oil is picked up from a particular oil field in a particular area. If it's impossible to identify, we still do pay for mystery oil spills, but it has to have come from a ship, not from an oil drilling platform or something like that. It has to have been, the likelihood is, have been from a ship, from a tanker. That's what we're talking about. Not just any ship, it has to be a tanker to be covered under the CLC and fund conventions.
Okay. Thank you very much, Mark. And I think we'll end it here. We have run just 5 minutes. Sorry for that. I hope we wanted to answer most questions, as many questions as possible. So thank you very much, everyone, for attending this webinar. Thank you for our experts who presented. Colleen, Aisha, and Mark, and Julien in the control room who dealt with the technical problem and flagged the question for us. There will be a summer break, so no webinars in August, and then we'll start again the webinar series in September, so stay tuned on our website, on our LinkedIn page, and I hope you will have a nice summer break, and see you soon. Thank you very much.